Hey guys, Dark Angel here. So this is going to be a reading of case called Hadfield versus London, 98 Washington, 657 168 Pack 516 1917. Washington Supreme Court case. And just to give you a little summary as to what the entire case is about. A lot of you haters, traitors, trolls, and bootlickers always trying to throw up the fact that the state was given the authority with its police power to regulate the highways and roadways, which you are right. They are given that authority to do that. But I'm going to actually show you what every single case, because this case right here was probably one of the best cases out of a lot that I've read, that actually cites cases from all around the United States in reference to that regulation that you guys keep relying on. And it's pretty much telling you what that regulation was actually for and why it was in place. And why it, not why it was, why it still is in place. Now, one thing that it doesn't tell you is how it managed to, how and who, because legislative sure didn't do it, but somehow it crossed over and everyone was included. Okay, but that's not a legislative bill. So unless one of you haters, traitors, trolls, and bootlickers can pull that House bill or that legislative bill that shows that it includes all and any automobile, motor vehicle, etc., within the regulations, sit down, be quiet, put your ears to the table, and listen to what I got to tell you, because you're about to learn something. So, in Hadfield versus Lundon, the plaintiff, on his own behalf, and in behalf of others similarly situated, seeks in this action to enjoin defendant as prosecuting attorney of King County from prosecuting persons for operating motor-propelled vehicles for hire. Did you hear that word? Hire. Upon the public streets of Seattle without having filed the bond and obtained the permit required by Chapter 57 laws of 1915. That's the exact same year that the Hendricks versus Maryland case was settled in. Ain't it? Rem Code SS 55 62 37. He alleged in substance that since the passage of that act up to and including a time shortly preceding the commencement of this action, he had been engaged in business of transporting for hire passengers along the public streets of Seattle in an automobile, obvious taxicab, that during such time he had on file with the Secretary of State a bond executed by a qualified surety company in the sum and conditioned as required by that act, that the bond has expired and is now under its terms null and void, that he has been unable to secure a new bond from any surety company doing business in this state, and that no such surety company will write such bond for him or for any other person engaged in a business similar to that of plaintiff, and that this, regardless of the financial responsibility of the applicant, that the Secretary of State threatens to and will cancel plaintiff's permit and will refuse to issue to him another permit unless and until plaintiff procures and files a surety bond as required by the act. He further alleged that the Mutual Union Insurance Company, a domestic mutual insurance company, has been organized and is authorized to write liability or indemnity insurance against loss or damage resulting from accident or injury suffered by an employee or other person for which the insured is liable. That such company has issued to plaintiff its contract for such liability in the penal sum of $2,500, which is by its terms assignable to the state of Washington in behalf of any person who may be injured through the negligence or unlawful conduct of plaintiff in the conduct of his business of carrying passengers for hire, that this contract has been assigned to the state of Washington. Talking about insurance, in the event that you didn't know. For the protection of any person so injured that, notwithstanding the fact that a solvent fund has been so provided, defendant threatens strictly to enforce such law and compel plaintiff to secure a permit from the Secretary of State and to furnish a bond signed by a surety company licensed to do business in this state, that such a course will force plaintiff out of a profitable and legitimate business and deprive him of his means of livelihood and inconvenience the public. Finally, it is alleged that such law is null and void because of so burdensome as to be unreasonable, because it is arbitrarily confiscatory, impossible of fulfillment, and tantamount to a prohibition against the carrying on by the plaintiff of a legitimate business. That its contravenous the Constitution of the State of Washington, Section 3, Article 1 thereof, and the Constitution of the United States, Article 14 thereof, in that it deprives the plaintiff of his liberty and property without due process of law and denies to the plaintiff the equal protection of the provisions of the Constitution of the state and the United States applicable thereto. Defendant moved to dismiss the complaint on the ground that it did not state facts sufficient to constitute a cause of sorry about that if you could hear that in the background. My daughter's having a tissy fit about her hair. 8-year-olds, go figure. Well, anyway, so yeah, I think I stapled this up just a little bit too high. Let's see, action. The motion was sustained and the complaint was dismissed. Plaintiff appeals. So now we're getting ready to get into some of the good stuff of the case, some of the meat and potatoes of the case, if you will. Because this case, like I said, it cites numerous cases. Appellant's contentions are, one, that Chapter 57 laws of 1915, page 227 Rem Code SS 55 6237 is unconstitutional, and that in any event he should be permitted to be assigned to the state and file the indemnity bond tendered in his complaint as a sufficient compliance with the statute. It is urged that the statute is unconstitutional and that it deprives appellant of his liberty and property without due process of law, thus contravening Section 3, Article 1 of the state constitution, and in that it deprives him of the equal protection of the law in contravention of the 14th Amendment of the federal Constitution. We have twice held this law constitutional. State versus Seattle Taxi Cab, 87 Transfer Company, 90 Washington, 416 156 Pack, 887 State versus Ferry. At 660 Hadfield versus Lundon opinion per Ellis. Now Ellis is the judge, in case you're wondering. Line Auto Bus Company, 93 Washington, 614 161 Pack, 467, but it is argued that in neither of those cases did it appear that bonds of the character prescribed by the law could not be procured, which fact does appear in the record now before us, and which it is asserted demonstrates the unconstitutionality of the law. We shall confine our discussion to a consideration of that question. The streets and highways. Now, this is here's where all you police officers, haters, traitors, trolls, and bootlickers need to understand this. This is the law, and this is for every single state. The streets and highways belong to the public. They are built and maintained at public expense for the use of the general public in the ordinary and customary manner. The state and the city, as an arm of the state, has absolute control of the streets in the interest of the public. No private individual or corporation has a right to use of the streets in the prosecution of the business of a common carrier for private gain without the consent of the state. There's your issuance of the license right there. To do business and to drive. They killed you with two birds with one stone right there. Nor except upon the terms and conditions prescribed by the state or municipality, as the case may be, the use of the streets as a place of business or as a main instrumentality of business is accorded as a mere privilege and not as a matter of natural right. State versus Seattle Taxicab 4 Transfer Company Supra, we said, as to those who were denied bonds, the act may be prohibitive, but this does not argue against its constitutionality. It in no manner proves that the regulation is unreasonable. Highways are constructed primarily as a convenient passageway for all of the people, and no one has an absolute right to use them for his own private gain. Are you catching the pattern that's starting to develop here? And no one has the absolute right to use them for their own private gain, even though such use be to carry over them people who desire the service. In Green versus San Antonio, Texas, as I said, this mentions a lot of different cases and areas and jurisdictions. They are going off of the state's power, the state's authority to regulate. They are going off of the state and the police power to regulate. Texas Civil Appellant 178 Southwest 6, it is said, so in this case, appellant has never had any vested right to use the streets of San Antonio to engage in the business of a common carrier of passengers for hire, and no right of his is infringed or invaded by the ordinance requiring certain things to be done in order to enter into business on the streets, which have at the expenditure of large sums been placed by the city in prime condition for automobile travel. Did you hear that? Any automobile that's doing business needs a license. Hadfield versus Lundon 661. The streets belong to the public, the city being its trustee, and no private individual or corporation has a right to use such streets for the prosecution of a business without the consent of the trustee and a compliance with the conditions upon which the permission to use them is given. LeBlanc versus New Orleans 138, LA 243 70 South. Damn, that's interesting because I just read that exact same passage in another case in another state. Hmm. Mm, mm, mm. The streets of the cities and towns in Louisiana among the things that are public and for the common use. No individual can have a property right in such use for the purpose of his private business unless speaking generally. That business being in the nature of a public service or convenience such as would authorize the grant, the right has been granted by the state, which alone has the power to make or authorize it, or by the particular city or town acting under the authority of the state. And in such case, the right can be exercised only in accordance with the conditions of the grant. That is to say, an individual seeking but not possessing a right of that kind may accept the grant with the conditions imposed by the offer, in which case he becomes bound by the conditions, or he may refuse to accept the conditions, in which case there is no grant, and without the grant so offered or some other from the authority competent to make it, he can never acquire the right to make use of a street as his place of business. License. They're talking about a license right there. All day, all night. Can't dispute it. They're talking about a license. Period. You don't apply for a license, you can't do business in our streets. Period. That's in Louisiana. The other one was in Texas. The other one was in Washington. So that's 3 states, different points of origin on the map. So you have one in the west, one in the south. Oh, actually 2 in the south, Texas and Louisiana. Two southern cases stating the same thing that a Pacific Northwest case says. See also the same effect, Memphis. Oh, Memphis got the same thing. Tennessee, there you go. Now we're going central. Street Railroad Company versus Rapid Transit, Tennessee. Let's see. I'm not going to get into all it. Memphis versus Stoll, X-Rail, RYALS. I have no idea what that means. Let's keep going. X-Party Dickey, 76 West Virginia, 576. X-Party Lee, 28 Cal, 719. Pack. Lutz versus New Orleans, 235 Fed, 978. These cases, though involving regulatory statutes or ordinance, all recognize and are based upon the fundamental ground that the sovereign state has plenary control of the streets and highways in the exercise of its police power, may absolutely prohibit the use of the streets as a place for business. This is straight from the law book, guys. I printed this straight from the pages of the law book. I didn't get it off Google. Thoughts of a patrol officer. Asking Google questions, knowing that Google gonna lie. But he one of them types that believes everything you see on the internet is the truth. Like a lot of you haters, traders, and trolls and bootlickers. Y'all go on the internet and think that that's God. It's not God. Okay, so prosecution of a private business for gain, they all recognize the fundamental distinction between the ordinary right, oh, here we go, of a citizen to use the streets in the usual way and the use of the streets as a place of business or main instrumentality of a business for private gain. The former is a common right, the latter an extraordinary use. As to the former, the right, the legislative power is confined to regulation. As to the latter, it is plenary and extends even to absolute prohibition. Now, what does that mean? It means that the legislation can't act against people's rights. Former, let me go back because I want to make sure you guys understand what this case law is saying right here, okay? because this case law just gave you your answer, all you haters, traitors, trolls, and bootlickers. This case has never been turned over. It's never been superseded. It's never been overruled. You can go look it up. This case right here is power. It's way better than Hendricks versus Maryland, the one you guys keep referring to. But I want to make sure that you guys know and understand this part right here. They all recognize the fundamental distinction between the ordinary right of a citizen to use the streets in the usual way and the use of the streets as a place of business or main instrumentality of a business for private gain. The former is the ordinary right. The latter is the place of business or main instrumentality of a business for private gain. As to the former, the legislative power is confined to regulation. As to the latter, it is plenary and extends even to absolute prohibition, since the use of the streets by a common carrier in the prosecution of its business as such is not a right, but a mere license or privilege. Oh my God. Angel, look at that law. I like good law, and it cannot lie. It's facts, and you can't deny. It's right there in your face because I just read it to you. Anyway, but a mere license or privilege. It follows, listen now, it follows that the legislator may prohibit such use entirely without impinging any provision either of the state or federal constitution. So if the legislation is confined to regulation, or the state is confined to regulation, and they can't act one way or the other against someone who's not doing business on the streets and just driving for their leisure in their personal private automobile, but they can do all that to someone doing business. Haven't you guys picked up the pattern yet? This has been ongoing throughout the centuries, for over 100 years. But for some reason, y'all ain't getting it. In Allen versus Bellingham, 95, WA 12, 163. But the use to which the appellant proposes putting the streets is not their ordinary or customary use, but a special one, meaning he wants to do a business. He proposes using them for the transportation of passengers for hire. See, told you. A use for which they are not primarily constructed. In the event that you don't know, the highways were constructed for public use, for the public, for private use. Yes, there is a case law on that that actually says exactly those words. As to such users, we think the power of the municipality is plenary insofar as this particular clause of the statute is commenced. It denies no form of regulation pertaining to business of this character, even to the prohibition of the business entirely. That language may be said to be obiter, but it states the correct principle as amply sustained by authority in Cummins versus Jones, 79, Oregon, 276, 155, Pac 171. The Supreme Court of Oregon, after discussing and quoting at length from many authorities, said, "We conclude, therefore, that since the ordinance in question is purely prohibitory, and cities have the undoubted right to prohibit such use of their streets, the demurrer should have been sustained. In Wade versus Nunley, 19 Tex Civil Appellant 25646 Southwest 668, the Texas Court of Civil Appeals said, the ordinance in question does not undertake to prevent or interfere with the right of the appealees to purchase, sell, or otherwise deal in the products referred to upon their own premises, nor does it prohibit other persons from carrying such products and delivering them to appealees upon their premises, but appealees have no vested right to make marts of the streets. Marts, you know what that is, right? Marts, business marts, alleys, and other public places, and to deny them the privilege of so doing is not to destroy or deteriorate any of their property rights. Boy, you people need to learn. Y'all people need to learn. You sit here and criticize me talking about I don't know the law, but I'm giving you straight facts and law. And not one time have you people even given me one thing that contradicted anything I said. Nothing. Your opinion. That's all you ever quoted was your opinion. You know, Fiddletown 2002. You cite some pretty good arguments there, bud, but you can't dispute these facts right here. Ex parte Dickey Supra, the Supreme Court of West Virginia, used the following language. Now, here you go. You done went from one end of the United States to the other end of the United States, to the southern end of the United States, to the northern end of the United States, to the central of the United States. Everything that you're hearing in this case is being quoted from the state's authority to regulate and the police power. They got this straight from that law. Straight from that. The right of a citizen to travel upon... here we go. This is from Virginia now. Keep that in mind. I just said this is from West Virginia. Dickey case. The right of a citizen to travel upon the highway and transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain. Now, I've had a lot of people tell me, oh, that ex parte Dickey case does not say that. The ex parte Dickey, well, that's funny. Here's a Supreme Court case. Hadfield versus Lundon, citing those exact words. Guess what? They're in that case. Because I don't think a Supreme Court is going to actually cite false cases. Come on now. Let's see. For private gain, in the running of a stagecoach or an omnibus, the former is the usual and ordinary right of a citizen. Here we go again. The former is the usual and ordinary right of a citizen, a common right, a right common to all, while the latter is special, unusual, and extraordinary. As to the former, the extent of legislative power is that of regulation, but as to the latter, its power is broader. Now, here's the regulation that they're referring to. They're not referring to license. Nowhere in any of that have you ever heard that they say, because you can't put a license on a right. Okay? You can't license a right, people. Simple. The legislation, the regulation that they're talking about, speed limits, stop signs, traffic lights, that's the regulations they're talking about. That they can regulate the speed of traffic within the city limits. Yeah, that's actually in another case that I was just reading earlier. That's actually in there. And that's actually the regulations that they are referring to when they say that they have the right to regulate traffic. They're not saying, oh, well, part of the regulation is you're required to have a license. Nowhere in there does it say that. Nowhere. The only license required throughout the whole regulation is to do business. You want to travel in commerce? Get a license. And you notice I said the word commerce because commerce means to do business or trade. Intra or interstate. Doesn't matter. intra or interstate. You need a license to do business, period. Never in history has a state and its police power ever been given the authority to regulate by requiring or demanding, I should say, a traveler to be licensed. Okay? So y'all need to get your understanding, because I challenge anyone to pull up the actual law, because I'm reading it to you. Pull up the law. Do your homework. And if you find anything in there that says that a right can be licensed at the state's authority and what have you, show it to me. You won't find one. I promise you. Because here's the standing law. What I'm reading to you right here is standing law. This right here took me a couple months to find. I finally found it. But like I said, I actually go to a law library, unlike a lot of you. You know, you rely on Google. Whatever. Anyway, moving on. The right may be wholly denied. Oh, let me go back up. Okay, the former is the usual and ordinary right of a citizen, a common right, a right common to all, while the latter is special, unusual, and extraordinary. As to the former, the extent of legislative power is that of regulation, but as to the latter, its power is broader. The right may be wholly denied, or it may be permitted to some and denied to others because of its extraordinary nature. This distinction, elementary, funny, and fundamental in character, is recognized by all of the authorities. What? Wait, did I read that right? This distinction, elementary and fundamental in character, is recognized by all the authorities. Supporting cases to support that: People versus Rosenhelmer, 209 New York. Now we done went all the way up to New York. Memphis versus State, ex-Real Royals. Supra, Fifth Avenue Coach Company versus New York. The regulation here involved, even considered as a prohibition, does not contravene the 14th Amendment of the Federal Constitution. It is settled that the 14th Amendment does not create any right in a citizen to use the public property in defiance of the laws of the state. Let me read that again. It is settled that the 14th Amendment does not create any right in a citizen to use the public property in defiance of the laws of the state. Lutz versus New Orleans, Supra. Also see Davis versus Massachusetts, 167. In other words, what they're saying is if you decide that you want to go and do a business, run a business out there on the street, and you don't have the proper permits, bonds, and insurance and license, you're defying the laws of the state. Now, I'm assuming that Fiddletown 2002 is going to say, oh, no, you misinterpreted that. No, I didn't misinterpret it. I didn't misinterpret it. It's right there in your face. That's pretty, like it said, it's elementary. If any proposition may be said to be established by authority, the right of the state in the exercise of its police power to prohibit the use of the streets as a place of private business or as the chief instrumentality in conducting such business must be held so established, nor can it be questioned, that the power to prohibit includes the power to regulate, even to the extent that the regulation under given conditions may be tantamount to a prohibition. Where the power to prohibit exists, the reasonableness of any regulation is palpably a legislative question, pure and simple. To hold otherwise would be to assert an absurdity when the legislator acts within its constitutional authority in the exercise of the police power. The expediency of this action is not a question for the courts. In such a case, the power once being established, the legislator determines by the enactment itself that the law is reasonable and necessary. State versus Mayo, 106 ME 6275. Imagine that. And that was actually cited from the actual regulation that's in place today. That's what that is. That's funny. That's funny. That's actually in a case that I was just reading about the regulation. That's actually cited in there. Imagine that. So, last page, last but not least. Oh, let's get that off of there. Okay, so the complaint before us shows that the statute in question not only could be complied with, but for over a year was complied with by the appellant himself. If, as asserted, appellant is now unable to meet those requirements because the character of bond required by the act cannot be secured, then he is not entitled to the privilege which the statute grants. And this simply because the grant was conditioned upon the meeting of those requirements. LeBlanc versus New Orleans, Supra. 2. The appellant urges that he should be accorded the right to procure a liability bond indemnifying himself against liability for damages written by the mutual union insurance company, and should be permitted to assign it to the state for the benefit of third persons who may be injured by the negligent operation of his vehicle, and file it in lien of a bond running to the state of Washington in the penal sum of $2,500, with good and sufficient surety company and a sufficient surety company licensed to do business in this state as surety to be approved by the Secretary of State, conditioned for the faithful compliance of the principle of said bond with the provisions of this act as required by Rem Code SS 556038. We have held that the mutual union insurance company cannot write the bond required by the statute. State XREL Mutual Union Insurance Company versus Fishback, 97 Washington 565, 166 Pack 799, McKnight versus Shabbat, November 1917. Oh, here's another case from the exact same year. Imagine that. Appellant does not claim that the arrangement such as tendered in his complaint would be a compliance with the law, but argues in substance that it is something just as good, but the courts cannot legislate. The law-making body acting within its undoubted powers has prescribed in plain terms the conditions upon which appellants and others in like case may use the streets in the prosecution of their businesses. The courts have no power to alter such conditions. The statute is too plain for construction. We are asked not to construe the statute, but to amend it under the guise of construction. We must decline that office. And the interesting part about that is Holcomb, Maine, Morris, Chadwick, Parker, Mount, Fullerton, and JJ all concur in that decision. The only one that didn't was Webster J. He took no part in the decision. So everybody, all the judges, 1, 2, 3, 4, 5, 6, 7, 8, eight judges are sitting up there citing to you the state's power to regulate and what they can and can't regulate. Right there. Now, if you don't understand what the legislation is confined to, the legislation is confined to regulation. Look that up. Again, no, I did not misinterpret the law. The regulation they're talking about is speed limits, traffic, signals, signs. That's what they're talking about. That regulation for the ordinary everyday use of the highway by a person in an automobile. If you decide to utilize that automobile for business to collect a fare, a fee, then you have to license that automobile. But if you are driving your automobile in just the ordinary course of everyday life, enjoying life and just kicking back with the sun in your face and the wind in your hair, I ain't got none. But and enjoying it for what it is, don't need a license. Never did. It's right there. I just read it to you. This case right here. Right there. Here, I want you guys to see that so you can look it up for yourself. Look it up. Look it up. Read it. Can you see it? There you go. Yeah. Look that case up. Anyway, the name of the case is Hadfield versus Lundon, 98 Washington. 657, 168 Pack. 516, 1917. Case has never been superseded or overturned or overruled. The regulations that they're talking about in there is the regulations pursuant to that of the Commerce Clause that is found in the Constitution, people. So with that being said, I know it hasn't, but I hope that it puts that what the state's authority and police powers authority to regulate to rest. Okay? What they can and can't regulate, put it to rest. Okay? Because, like I said, all of you keep getting on here making comments and arguing and stuff, but none of you have ever come up and showed the law that actually shows where it says the state has the authority and the police power to regulate anybody who wants to travel on the roads, whether they're doing business or not. And I'm using the term travel because I do not use the term drive. So, if you want to travel in business and you're doing business on the streets, yes, you need a license. You're traveling in commerce, yes, you need a license. Oh, wait a minute. The DMV, the license they issue is to do commerce. Whoops. So you're licensed when you went to the DMV and you registered your automobile. And of course, you've heard me say this over and over again. And so I'm going to repeat it one last time. Anytime you go register your automobile at the DMV, you automatically enter into their commerce. You just entered into their jurisdiction. Now you are required to have a license and a registration on your automobile. Okay? There's that. State law cannot contradict federal law. There's that. Okay? Article 6, Chapter 2 of the Supremacy Clause, federal law trumps state law. All the time, every time, anytime, a state law is in conflict with that of the federal law. Nowhere in the federal law does it say that you need to have a license to operate, travel in your automobile. Doesn't say it. Sorry. Well, anyway, with that being said, guys and girls, let's put that one to rest. This one's in the books. This is Dark Angel. Deuces.